infringing on your intellectual property, how do you go about sending a cease and desist as a company? Today, we're talking to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School and have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Tony, we have been talking a lot about cease and desists here on the platform, especially given what happened to me and my stolen content last week. And so I want to talk a little bit about what happens when you, as a company, need to send a cease and desist to somebody else. So, from a legal perspective, what do we need to talk about?
Yeah, you need to make sure that you have all your ducks in a row if you're going to essentially prepare a cease and desist letter. So, first things first, as we discussed the last time about this topic, it's important to gather all the evidence that shows some type of infringing use. So, for example, if let's say in your case, Cam, your video was infringed on, having screenshots of the infringement is going to be valuable, even if it's not practical to send a screen recording necessarily with the cease and desist. But we live in a day and age where email is a thing, and we have WeTransfer or Google Drive or other ways of sending links or information out to people. So there's certainly a world where you could draft a cease and desist letter. You can grab screenshots of the infringing use, but then you could supplement it with maybe a link that shows the video in context being used. All that to say, having all those screenshots that show the infringing use is necessary. So that's going to be important because God forbid that's taken down, at least you have some type of proof that the use was infringed on. Number two, making sure that your work was properly registered in the U.S. Copyright Office. There's a case that went down recently in the Supreme Court a few years ago that ruled that you have to have a work fully registered in the U.S. Copyright Office with registration number and all in order to pursue a copyright infringement claim. Formerly, it used to be where you could have a pending registration with the U.S. Copyright Office, and while you're waiting for the registration number, you could go ahead and file a copyright infringement claim if you so desired. But that rule has changed. So I think, if you're the type of person who has been very prone to copyright infringement claims or has been the victim of some type of infringing use, I think creating a very proactive regimen, while it might be very tedious, but creating a proactive regimen of taking your copyrighted works and registering them in the U.S. Copyright Office will be a great measure to do, because at the end of the day, at least you can say that you've taken a proactive measure to protect that copyright. One thing I'll say about registration with the Copyright Office and copyright infringements: if let's say you discovered an infringement today and then tomorrow you decide to register the copyrighted work and you get a registration number 3 months from now, you can still pursue a copyright infringement claim, namely for two reasons. One, the way the statutory language is laid out, it allows for 3-year statute of limitations upon the date of discovery. And two, even though you haven't registered the work yet, nothing's precluding you from bringing that copyright infringement claim, so long as, again, you're filing the infringement claim within 3 years upon date of discovery. Now, that said, the way the language is laid out in the Copyright Act, you can only collect for actual damages. So that could be what you would normally charge, let's say, for some type of use of your copyrighted work in some type of manner, let's say commercial nature or otherwise.
Mm-hmm.
If you registered the work in the Copyright Office the day you created it, 3 months pass, you get your registration number, but 6 months from now, somebody infringes on your work. Now you can sue for actual damages, but then you could sue for a little extra. You could probably get, not necessarily punitive damages, but you can get treble damages, which is kind of like a little extra something that would allow you to maybe recoup losses from attorney's fees, or, I don't like to call them like the extras, but I guess like if you want to call it that, that's the easiest way to call it. So that's one thing to bear in mind. Registration, it's very, very important. That's going to be paramount to this whole process. So, and then of course, I think most importantly, once you've done all that legwork, getting the screenshots, getting your registration in the U.S. Copyright Office, then the next step would be working with the lawyer to help you draft that legal language. There's specific language that would have to be laid out, especially pertaining to what rights were violated by the infringer. You could talk about the fact that you created this work of authorship and you registered it in the US Copyright Office, but the lawyer will help create a roadmap of what's essentially going to be in the next step. Usually these cease and desist letters operate as mitigation tactics before you escalate it to an infringement claim. So it's essentially an extension of an olive branch, and a lawyer will know, depending on, I guess, the tenor of their, of their writing, and certainly the style of lawyer that they are, if they're an aggressive type of lawyer, or if they're more of like a cool, calm, collected person, they're going to write this cease and desist letter in their style and enforce your rights on your behalf. So all that to say, I think having a lawyer walking you through that process, even drafting it for you, and obviously you hiring their services to do that, is going to be paramount. So I think those are the main steps that it would take to get a cease and desist if your work has ever been infringed on.
And I think it's really important to reiterate that it's not something you have to do the second you see the infringement. Sometimes we will get so emotionally invested in these things that we want to jump right into those conversations, but we have quite a bit of time to actually go through this process. So we have the ability to get together all the information we need to prove our points. We have the time to find a lawyer if we don't have one already, and then we have the time to have those discussions before we have to file anything. So when it comes to sending those cease and desists, we always want to make sure that you are working with your lawyer. It's incredibly important to make sure you have somebody who understands the legalese of all of it, because you and I don't. And so make sure you have somebody who gets it, who understands it, and can work on your behalf to make sure that everything is in alignment before you are sending these out. Tony, final thoughts on cease and desists from the company's perspective of sending one?
Yes, one other thing I should mention, cease and desist are not exclusive to copyright infringement. It could also extend to trademark infringement. It could even extend to patent infringement. So I think it's important for brands to know, or other people that have created copyrighted works that are the subject of an infringement, it's important to know that if any aspect of your intellectual property rights have been violated, the cease and desist is the tool that would allow you to begin the process of enforcing those rights. So again, kind of the same story. If we're dealing with a trademark infringement matter, it's a matter of verifying if your logo or word mark or anything of that sort has been registered in the US Patent and Trademark Office. If your patent is the subject of the infringement, has your patent been registered in the US Patent and Trademark Office? So that, I think, I just want to highlight very, very importantly that cease and desist are not mutually exclusive to the world of copyrights. It extends to all aspects of intellectual property law.
And one thing that does come up anytime you and I have a conversation about cease and desist is that this really truly is an olive branch. It is not immediately jumping to a court case and suing people and having an aggressive conversation. It is a way to make things better before it gets worse. And so while we sometimes feel like it can be a little abrasive, this is actually the best course of action because it gives people the chance to rectify the situation and to course correct before it gets worse. If you have further questions on sending a cease and desist, go ahead and let us know down below. And if you are somebody who just got a cease and desist, stay tuned because in our next episode with Tony, we're going to break down how you can be responding to that. Tony, where can everybody reach out to you online in the meantime?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can check out my brand new entertainment law podcast, and Scene, on Spotify, Apple Podcasts, or wherever you listen to podcasts.
Hit the subscribe and notification bell so that you don't miss out on any of Tony's episodes. We're recording weekly episodes, so if you've got questions, now is the time to drop them down in the questions and in the comments below so we make sure we know exactly what you need help with to make sure you're being as profitable as possible online this year. And make sure you are following along for daily episodes helping you level up on navigating the world of social media and becoming more profitable online. We'll see you in the next episode.